Hi, I'm Carrie Payne from Business Depot Legal. Challenging an estate is generally a term used for describing someone being upset with the terms of a will. A will can be contested on a number of different grounds, including proper provision was not made for you in the will, a promise was made to you that you would be left a certain part of the estate and that has not occurred, there was a clear error or mistake in the will and a court order is sought to rectify that error or mistake should be fixed, the will maker lacked capacity to make the will, and finally the will maker was unduly influenced when they made the will. Today we're going to focus on the first of those grounds, being a lack of proper provision. The formal process for a claim of this kind has different names in each state, but the purpose of the legislation in each state seems to be consistent, that there are certain people that a deceased person should adequately account for when dividing their estate. Broadly speaking, to make a claim of this kind, the person claiming will need to, number one, fit within the category of person that can challenge the terms of the will, and number two, go about providing evidence that they were not adequately provided for. Viewers should be aware that each state has its own time limits regarding that when a claim of this kind can be made, and as always, specific advice should be sought. So who can challenge an estate? Again, while each state has its own categories of claimant, broadly speaking, the people that can seek further provision from an estate with respect to the deceased include spouses, including ex-spouses, children, including stepchildren, and finally a person that was dependent on the deceased at the time of their death. So how does the court determine whether someone has been adequately provided for? Ultimately, the court decides whether a person should receive further provision from the estate of a deceased person. While there are no hard and fast rules about what circumstances a judge must take into account, the cases highlight that the following points are to be considered as important when deciding whether further provision should be made. Number one, the size of the estate. Number two, the financial and physical needs of the person challenging the estate and the same needs and priority of the other people the deceased had to provide for. And finally, the relationship between the deceased and the person challenging the estate, including any conduct which may be called disentitling. It is important that people consider whom, if anybody, they should be providing for in their estate plans. While there are steps that you can take to reduce the likelihood of a successful challenge, specialist legal advice should be sought regarding what might be appropriate in your circumstances. Get in touch with us at Business Depot Legal for a chat at businessdepot.com.au/legal.